This is the Hidden Killers Podcast with Tony Brueski.
Featuring defense attorney, Hidden Killers daily contributor, and host of the Defense Diaries podcast, Bob Motta.
The road to a new trial for Alex Murdaugh, well, it could be a long one, if he even gets there. That is the question that we are asking today, as Judge Toal already said, nope, I don't think so, but more so punted it down the road to another appellate court at some point in time, possibly. Here to discuss, Bob Motta, defense attorney, host of the podcast Defense Diaries. Bob, what is the next steps for Alex Murdaugh going forward?
Appeal.
Yeah.
Same thing. So that, that issue will, and Judge Toal knew it.
Mm-hmm.
Like she said it at the end of the, when she kind of went through her little soliloquy at the end there, she was very firm in her position, which, if you saw her rulings going in, I knew she was going to deny it.
Mm-hmm.
Like she made it extremely difficult for them to be able to meet their burden, them being the defense. And she selected, what the standard that was going to apply,
mm-hmm.
which was the defense was arguing any contact with the jury is grounds for retrial.
Mm-hmm.
And she was, no, that's not what I believe it is. I believe that it has to be shown that the contact with the jury affected their final outcome or verdict.
Mm-hmm.
And when she said that, I knew. And then you had kind of the one juror Z, or I think they're referring to it. When Juror Z comes in and says, well, yeah, it affected the outcome. It affected my vote.
That's the argument here is I thought they reached the bar of what they needed to do, because the bar was, did it affect the vote? And then it felt like Toal kind of pulled the goalpost back a little bit, going, well, what was Becky's intent? Does it matter what Becky's intent was, if that's what the outcome of this choice was? I mean, if you drove through a crowd of people with your car and you run a bunch of them over, but your intent was simply to get to the Panda Express down the road, does it matter that you ran over those people? I would think it does matter that you ran over those people, even if it wasn't your intent.
I agree. And I think ultimately Toal was of the mindset that she's kicking this can down the road, man.
Yeah.
Like she wasn't, and she's got a very storied past. Like she's a hell of a jurist. I mean, she was on the Supreme Court. She was the Chief Justice of the South Carolina Supreme Court for a good period of time.
Yeah.
And then an associate judge on the Supreme Court, so she's a very learned woman.
Mm-hmm.
And extremely experienced. And, I think she made the decision she was going to let the higher courts deal with it. She made her rulings and she was standing by them.
Did she already have
damn
her,
well it was going to get kicked up? Like she knows.
Did she already have this decision made even prior to going into it? And I think that's a big thing because, very learned woman, very intelligent, has tons of experience, very well respected. And I guess that's kind of where I'm surprised, just kind of as a layman, of like, you're really good at this. What you said and what you did really doesn't reflect that.
Right. I know. I think for I felt the same way about the trial judge. And I think there exists a concept with trial judges that understand that they would rather be overturned on appeal than be the bad guy at that level or bad gal at that level and make a decision that is not going to be popular with the public at large. I mean, I know it's not supposed to factor in, but again, they're all human. We're all human. It does factor in. I think ultimately, I think she absolutely knew going in that day. I mean, she ruled from the bench. Mm-hmm. She didn't take it under advisement. And she couldn't have known that Juror Z was going to come in there and say, I don't think that there was going to be anything that was going to be done in that courtroom that day that was going to change her decision. Yeah. So my gut is, she fully knew the way she was going to go. I mean, when you rule from the bench like that, without taking under advisement, that tells you the judge was decided going into the hearing.
Yeah. Yeah. Let's talk about Juror Z for a second, because, I mean, it is rather interesting, the fact that we had one out of the 12 jurors that seemed to have a very different recollection of what occurred in that jury room and the interactions with Becky. Everyone else saying, no, these things did not happen. I did not affect my verdict because I don't remember her ever saying these sort of things to me. Is that odd that you're going to have one that has such a different recollection of the events that took place?
I mean, it really is. It kind of goes to that thing where I think we were talking about a few episodes ago where you're like, you get that one juror who's like, oh, yeah, they formulate the plan, the money-making plan. Oh, yeah, you know what I mean? It's like, I'm going to write a book. I'm going to get some interview money here out of this thing. And then, because it's, to have all the other jurors say that it didn't happen is weird, right?
Yeah. At the very, and I know nothing about Juror Z. I'm not making an accusation that they're doing anything improper, but it is odd. I mean, and it certainly was worth speculating on, like we did the other week of, well, I mean, there's got to be some incentive here if you're going to be the one that's going to try and hang or change the verdict of the Alex Murdaugh trial, and you're the one who comes out and says these statements, but it still didn't work. That being said, though, this is going to get punted down now to an appellate court. Is it going to be the same sort of process again with all of the jurors coming back in, or are they going to use the existing testimony from this for the appellate court to make their decision?
That's right. It'll be now no witnesses at the appellate level. It all is from the record. So like they'll rule on the record and apply the law, So yeah, no, it will, like this evidentiary hearing was one and done.
Okay.
I mean, theoretically, what could happen is the appellate court could say, all right, we've reviewed the record. We believe that Judge Toal applied the wrong standard and we're kicking it back down for another evidentiary hearing. So, I mean, that could happen, because he's still got his direct appeal as well, because this was really a collateral issue. I mean, kind of in that, all the things that they'll be arguing about in his direct appeal, whether or not Newman went too far in allowing the financial crimes in, and that went on for 3 weeks, like all those different issues will be brought up in his direct appeal. So this one, will probably be, I'm assuming, lumped in there, or they'll just appeal this decision on its own.
Yeah.
Oh,
that being said, and knowing what you know and doing what you do, where do you think this is going to end up? Do you, in your opinion, your conjecture on this, do you think at some point in this process, Alex Murdaugh is going to end up with a new trial, or is the decision of Toal going to stand?
If they're going to do the right thing, as much as nobody wants it in terms of cost and going through it again, I mean, to me, it's a very slippery slope to allow for a clerk or anybody to have conversations with the jurors. I mean, it's verboten. It's not allowed. Can't do it. The judges give speeches to the jurors, when they're sitting in the jury box, like, look, the lawyers are going to avoid you like the plague not because they don't like you, because we cannot even have the appearance of impropriety, let alone actual impropriety.
Sure.
And to me, short of somebody coming up with some evidence that Juror Z is making this shit up out of whole cloth, I don't know how you don't give him a new trial. Because you've then set a precedent that it's okay, that there's a certain amount of communication that it's allowed to happen with the jury.
You can't have that. Yeah.
It can't happen, dude. It changes the entire system.
Yeah.
I'm hoping that the appellate court does it right, not because I like Murdaugh, because he's a giant piece of shit, but because I care about the Constitution. I care about how the system works and operates. And that is a very slippery slope to have precedent out there saying that a certain amount of contact, especially of that ilk, where she's saying things. It's not just like, oh, what do you want for lunch? Oh, I mean, obviously you're going to always have a bailiff or a clerk that's going to tend to the jury. This is different. This was her talking about the case.
Yeah.
So, I mean, I hope the appellate court kicks it back down for a rear hearing, for like an actual hearing with the proper standard. Because I agree with the defense. Any communication regarding the case with the jury is improper and call for a retrial. Like that was the defense's, that was their position in terms of the standard, and I agree with them. And I think that should be the standard. Like, why do we need to make any kind of rule that makes it allowable for people in positions of power to be discussing anything with the jury? Mm-hmm. Like, no one's going to be able to make an argument to me that's going to make that okay or make it make sense. It's like, it's not allowed for a reason.
Want to listen ad-free? Want advanced access to all of our interviews before anyone else?
Become a True Crime Today Premium Plus subscriber on Apple Podcasts.
You get every episode commercial free.
So you can binge on true crime
until you can binge no more.
Search True Crime Today Premium Plus on Apple Podcasts now, or go to our podcast page and sign up now.
More of the Hidden Killers podcast next.